I should like to look at this subject from the perspective of a relatively new commercial court like mine, engaged in setting up its own rules and procedures. We were drawing not on our own experience of litigation funding, for we had none at that stage in our history. Instead, we were drawing on what others had done who had had that experience and had learned how to deal with it. I wish to pay tribute, especially to the way third-party litigation funding is dealt with in Singapore. I made no secret of the fact that to begin with, we were wondering whether the better course would have been to do nothing at all, have nothing to do at all with litigation funding, on the view that it was likely to do more harm than good to the interests of justice in our courts. The common law rule against champerty has cast a long shadow. But having seen what Singapore was doing, we were persuaded that the better course was to come out into the open, to acknowledge its existence, to recognize that it has value in enabling genuine cases to come to court, which might otherwise do so, and to develop the rules that are needed to make it work in the best interests of the court and its litigants. There were two key points that guided us as to what we should do. First, we needed to establish a set of rules with which a litigation funding agreement in our courts must comply. And second, we needed to carry practitioners with us in their development. What we were seeking to do was, in effect, to lay out the conditions with which the funder had to comply if the agreement was to be enforceable. But it did not seem to us to be either sensible or appropriate for the court to become involved itself, by insisting, for example, that the funder must disclose the agreement to the court for its approval, or for the agreement itself to be subjected to the court's supervision. The right approach, we thought, was to leave these agreements in the hands of the parties themselves. We wanted to avoid the risk that the court might be influenced one way or the other by knowing that there was such an agreement in the handling of the case. It was enough, we felt, to use enforceability as the key to the way we were to design our rules. Funders, after all, are not in the funding business to dispense their assistance to litigants for free. They need to be able to enforce their agreements. They need to know that when it comes to enforcement, their agreements will be respected in full measure by the court, and that they will get a return on their investment. Carrying the practitioners within the development of our rules was, as we saw it, essential. That is because they are so much closer to this part of litigation practice than the judges in our courts. So their advice played a major part in the shaping of the rules that we now have. What then do the rules say? They fall into two parts. The first part sets out requirements that a funder must satisfy when the agreement is made and must continue to satisfy. It must not be a party to the business that it is funding, and to ensure that it has sufficient resources to carry on its business, it must have assets of not less than $5 million or its equivalent. And it must not be owned directly or indirectly by a lawyer or a law firm. The second part is concerned with the agreement itself. The aim is the protection of the litigant. The funder must ensure, among other things, that the litigant has received legal advice and confirmed in writing that it has done so. There are obligations about confidentiality, about respect for the court's rules of conduct, and avoiding conflicts of interest. And the funder must state in the agreement that it submits to the jurisdiction of our court for the purposes of any disputes about the agreement. The points that I would emphasize then are these. Litigation funding has to be recognized as something that is here to stay. Financing spurious claims is to be deprecated, of course, but that is not what those who are in this line of business are about. On the other hand, if they want their agreements to be enforceable in our court, the funders must play by our rules. Thank you.